this August gathering. My dear brother, Justice Kaushik Goswami, whom I had the privilege to recommend for elevation as a judge of the Guwahati High Court, and he has done me proud. A big round of applause for Justice Kaushik Goswami. The dynamic Advocate General of Assam, Sri Devajit Saikia, Senior Advocate, who also happens to be the Secretary of the BCCI, I'd like to share with the August gathering that when I delivered my farewell address, I called upon the advocates of Assam to learn the art of assertion from Sri Saikia. All these law students who are present here must listen to him arguing. If you want to know what art of assertion without sounding offensive is, so the persuasion which comes in from the art of assertion, he is the best example for that. The dynamic Vice Chancellor of this grand university, the Royal Global University, Dr. Pansare, Dr. Buragahin, Vice Chancellor of the Royal Global University, Sri Raktim Dwara, Registrar General, Guwahati High Court, other registrars of the Guwahati High Court, a master at his art of advocacy as well as a quiz master of the highest caliber, Sri Anshuman Boda, Senior Advocate, Guwahati High Court, my dear wife, Mrs. Mehta, esteemed faculty members, mentors, professors, and above all, dear students, gracious ladies and gentlemen. It's really a moment of joy and privilege for me that I stand before you today in this magnificent campus of the Royal Global University. To say that I am overwhelmed by the aura of this institution is an understatement. Friends, this city of Guwahati, the state of Assam, and as a matter of fact, all the 4 states under the Guwahati High Court are very special to me. That blessed day of 15th February 2023, when I took oath as the Chief Justice of the Guwahati High Court, is one of the most precious days in my life. I treasure it and shall continue to treasure it for the rest of my life. I return every visit to Assam is like coming home. Not a day passes when I don't remember our time in this vibrant state of colors, greenery, music, and spirituality. The most beautiful facet of this state, which I often refer to my friends and colleagues, is the ultimate example of secularity which it displays. When I was looking at the administrative matters of the High Court, I was surprised to note that there are hardly any special courts for trial of scheduled caste and scheduled tribe cases in Assam. I asked my registrar, what is the reason? And I was pleasantly surprised to know, sir, there are hardly any cases, which is a direct proof, direct evidence of the fact that this state does not know the definition of racism. And that's remarkable. During my tenure, the 8.5 months tenure as the Chief Justice of the Guwahati High Court, I not only engaged with law, but also with the warmth of the people of Assam and Northeast. And I am beholden to each one of them. Those wonderful days shall remain etched in our hearts for times to come. We today before coming to this auditorium, unveiled one of the largest gavels, and the most amazing part of the story is that the gavel has been crafted by none other than the students of this university. I am truly impressed. I congratulate each one of you who has been a part of creation of this magnificent structure. The gavel, simple in appearance yet profound in meaning, embodies the solemn authority of law and justice. Each strike of the gavel is not merely a sound, it is a call to order, as the Honorable Chief Justice said, a reminder that reason must prevail over chaos and that disputes must yield to the discipline of law. In classrooms, it inspires students; in courts, it guides judges; and in society, it stands as a metaphor for fairness, finality, and the quiet strength of institutions. By unveiling this gavel, we are just not celebrating a ceremonial object, but reaffirming our shared commitment to the rule of law and the ideals of justice that bind us all together. Today, dear students, I speak to you not in a court of law, but in a temple of learning. And the subject which is assigned to me is one that demands both legal wisdom and youthful imagination. A very well chosen subject by the respected professors of this university, and which is contemporary to the core: digital arrest and privacy rights, navigating law enforcement in the era of surveillance. Every citizen of this country is today facing this threat. And I'll confess that I am not untouched. I also received a couple of such calls. Of course, the fact that my mind is attuned, having worked on the criminal side, attuned to these kinds of happenings, I was lucky enough not to fall prey for the perpetrators. The relationship between crime and technology is as old as civilization itself. Every new tool of human progress has also been co opted into the arsenal of wrongdoers. The printing press enabled mass education, but also forgery. The telegraph connected continents, but also allowed the swindlers to deceive across the borders. In present times, however, the pace of technological transformation has accelerated so dramatically that crime has not merely adapted, it has metamorphosed. Traditional crimes of theft, extortion, and fraud, once defined by physical presence and tangible coercion, have now been reimagined in digital form. A pickpocket once needed to jostle in a crowded bazaar to snatch a purse. Today, the same act is accomplished by hacking a mobile wallet from thousands of miles away. While once fraud required forged documents and physical signatures, it now requires only a convincing deepfake video or a manipulated voice recording. Artificial intelligence, augmented reality, the dark web, and algorithmic precision have given criminals the ability to target victims with unprecedented sophistication. Personal data, once protected in dusty files locked away in government cupboards, is now stored across countless servers which are vulnerable to breaches. Equally worrying is the shadowy realm of the dark net and the dark web. Hidden from ordinary search engines, it has become a marketplace for stolen data, hacked identities, narcotics trade, illegal arms trade, and even services that facilitate financial frauds. Many of the digital arrests and the related scams are perpetrated on networks operating through these concealed platforms where anonymity is weaponized. The dark web represents the underbelly of the digital age, an invisible frontier where crime thrives beyond the sight of ordinary users but with very real consequences for the society. Hence, the crime syndicates, once restricted to their immediate geography, now operate across continents with consummate ease, coordinating scams from Noida to Nairobi, from Hyderabad to Hong Kong. The phenomenon of digital arrest illustrates this transformation vividly. Here, the crime is not committed with guns or weapons, but with fear and manipulation. Victims are coerced into staying under constant gaze of fraudsters through video calls, made to believe that they are under investigation by law enforcement agencies, and gradually stripped of their financial resources. The victim's liberty is curtailed, their dignity eroded, and their resources drained, all without a single policeman, a prison cell, or a warrant. It is an arrest without law, an incarceration without walls, and that is why the term digital arrest. My friends, let me now turn to the question that troubles both jurists and the citizens alike. Where does the law stand on the so called digital arrests? Let us be very clear. There is no concept of a digital arrest in law. Perhaps the Advocate General is here, perhaps the state of Assam will come up with a legislation very soon, wherein the digital arrest is also marked as a formal crime. It is given a name, it is given a punishment. Neither the Bharatiya Nyaya Sanhita 2023 nor the Bharatiya Nagrik Suraksha Sanhita 2023 recognize such an act. An arrest in India cannot be made over Skype, WhatsApp, or Zoom. There has to be a formal arrest. It cannot be ordered by a faceless caller pretending to be the police or the enforcement directorate. It must be physical, it must follow due process, and it must be accompanied by safeguards such as an arrest memo, identification of the officer, judicial oversight, and most lately, communication of grounds of arrest. Yet the criminals have exploited this very gap. They pose as officials of the RBI, the CBI, or the enforcement director, and nowadays a new technology has come in, wherein they pose to be the agents of the couriers. They give a call saying that a packet has been received in your name, and the customs authorities are asking questions. They isolate the victim, continuous calls, and threaten them with imaginary cases, keep them under constant video surveillance until the victim pays or breaks down. This is not law enforcement. This is extortion, plain and simple. Sextortion and honey trapping are yet another classic examples of digital arrest followed by blackmail and duping of money. The statistics are sobering. The phenomenon of digital arrest demonstrates this transformation vividly. I'll give you a few examples. Of course, with the digital age and smartphones in every hand, this information is disseminated very fast. But still, the instances need to be recollected every moment so that you don't fall prey to the very same fraud. A retired Air Force officer in Noida was kept on continuous video calls for 37 days by the fraudsters who were posing as enforcement officers. Isolated from his family, convinced that he was under investigation, he was forced to pay verification sums amounting to more than 3 crores. His liberty was curtailed not by handcuffs but by fear. But this is only one face of cybercrime. In Pune, a software engineer invested through a fake online trading app, watching illusory profits of over 7 crore rupees appear on his screen, even as he lost 64 lakh rupees of his real money. In another case, in Hyderabad, a young engineer was lured into a video call, blackmailed with explicit footage, and was forced to pay a sum of rupees 1.7 lakhs in a sextortion racket. In Delhi, citizens receive fake traffic challan messages. Clicking the link gives the hackers a remote access to their mobile phones. One of the victims lost about 1.6 lakh rupees before the fraudster was luckily arrested. The scale of this crime is not limited to individuals. Organized cyber syndicates now span over states and nations. One such call center was recently unearthed in Delhi. The Enforcement Directorate unearthed that global fraud which had duped the citizens in United States of about 260 crores. These scammers, posed as Microsoft and Amazon support staff, funneled illicit money through cryptocurrency and Hawala networks. In a remarkable example of international collaboration, the CBI and the FBI cracked a $40 million fraud ring which was being operated from Noida and Punjab, where the call centers were established. These scamsters preyed upon overseas victims by impersonating technical support agents. It's very easy for those countries. Herein, we have got service centers, young people coming forward to provide their expertise. But in those countries where the populations are dwindling, people depend on online service facilities, and they are the most easy prey. Even local governance has not been spared. In Aligarh, the hackers broke into login credentials of a village panchayat secretary and issued nearly 600 fake birth certificates across multiple states. In Jharkhand, which has the dubious distinction of large number of scamsters, the police uncovered a 32.6 crore mule account network spanning Bihar, Odisha, and Uttar Pradesh, involving 15,000 accounts used to launder cybercrime proceeds. I'd like to tell you here that Jharkhand, villages in Jharkhand, and now some villages in the Bharatpur district and Alwar districts of Rajasthan have the dubious distinction of being the epicenters of this cybercrime networks. The promise of new age investments has also not remained untouched. In Telangana, a businessman was duped of rupees 4.9 crores in a fraudulent cryptocurrency scheme where criminals posed as expert traders. The story of cybercrime, therefore, is not limited to one city or one class of victims. It spans from rural panchayats to the metropolitan banks, from students to seasoned professionals. Perhaps the most audacious example is where fraudsters created a fake Supreme Court online proceeding with a fake judge impersonating one of the former CJIs and circulated a forged notice extorting money from a businessman under the guise of judicial authority. When even the highest court of the land is impersonated in cyberspace, it is a stark reminder that no institution, no citizen is beyond the reach of these crimes and criminals. Technology, my friends, has altered the very character of crime. We recently saw in the Operation Sindoor, most of the warfare was fought with remote access, from remote access locations, drones, wherein human interference was hardly required. This technology has made the crime borderless, faceless, pervasive, and omnipresent. Unlike conventional offenses, where the victim and the perpetrator often meet in space and time, cyber crimes are often orchestrated in anonymity, with perpetrators shielded by layers of encryption, false identities, and jurisdictional loopholes. This anonymity not only emboldens the criminals but also multiplies the difficulty for the enforcement agencies. In this sense, cybercrime represents not merely the digitization of old offenses but the birth of new forms of criminality. A digital arrest is not merely an online version of extortion, it is a new kind of psychological captivity. Sextortion, phishing, crypto scams, and AI generated frauds are not replicas of past wrongs. They are qualitatively distinct, exploiting vulnerabilities that arise only in the digital ecosystem. Thus, the story of crime and technology is not simply one of continuity but of rupture. Technology has just not raised the level of crime, it has altered its grammar, its scale, and consequences. For the law and for the courts and for the society, this transformation demands not only new tools of investigation but also new frameworks of understanding, because the crimes of tomorrow will not resemble by those of yesterday by any stretch of imagination. Now, what has the judiciary done about it? The judiciary has been swift to recognize that the cyber crimes demand a completely new paradigm of investigation and adjudication. I would like to refer to a few decisions to contextualize this issue. In Satyendra Kumar Antil, the Supreme Court issued a direction prohibiting police officials from sending notices by WhatsApp and directed states and union territories to issue orders to the police to ensure that the service of notice under Section 41A of the Code of Criminal Procedure should be strictly in accordance with those laws. Similar directions have been issued with respect to summons under Section 160 and 175 of the CRPC. At a first glance, these may appear to be narrow directions, but in truth, they strike at the very root of the menace we have been discussing. But mind it, my friends, now with the technology invading the legal spaces, we have started switching on to electronic service. Imagine a situation wherein a litigant receives a WhatsApp message portraying that it is a message sent from the court in form of a summons, and as a matter of fact, it is a message from a scamster. You click the message and you are under a digital arrest. So this is a reality which we will have to face. For too long, fraudsters have proved even innocent citizenship, preyed upon innocent citizens articulately, or particularly the elderly, by sending false notices and video calls, pretending to be the police or the investigative agencies. By restoring uniformity, insisting on strict compliance with law, and refusing informal modes such as WhatsApp, the court in Satyendra Kumar reaffirmed constitutional safeguards and also closed the door that fraudsters may have exploited. In New Space Research and Technologies versus State of Karnataka, the Karnataka High Court captured the reality of the new age offences in striking words, and I quote, The crimes over the years have emerged in different hues and forms. In this digital age, where crime knows no borders and malfeasance is coded with keystrokes, the tools of investigation of such emerging crimes must evolve. An ordinary investigating officer would not be equipped with to decode the labyrinth of cyber crimes. If the crimes are sophisticated, the investigating officers need to be updated. The court went further to direct the establishment of specialized cyber command centers, stressing that, and I quote, if a cyber command center is established to combat cyber crimes and strengthen cyber security, it would usher a new beginning of tackling the new age investigating centers. New age crime with the new age investigating centers. Such cyber command centers should be made meaningfully functional by appropriate officers. Only then will the state leap forward to tackle the emergence and growth of cybercrime. Unquote. In Sumit Nandwani versus State of Haryana, the Punjab and Haryana court reflected on the daily anxieties cybercrime has created for ordinary citizens. It noted citizens contend with the pervasive threat of cybercrime, leading to a heightened sense of vigilance and caution. This apprehension has led a majority of people to refrain from answering calls from unfamiliar numbers, even when such communication may be necessary. Proficiency in technical knowledge or academic attainment does not necessarily confer immunity against cyber threats, as cyber criminals often possess superior skills and tactics. The court warned that the fraudulent operations run from Indian soil have not only harmed victims but also tarnished India's reputation globally. It called for immediate reforms in the telecom regulations, particularly in curbing the misuse of prepaid SIM cards, which remain the backbone of many cyber scams. The Rajasthan High Court, in the case of Rakesh Totuka 2025, observed in the age of rapid change of digital evolution, digital scams have emerged as one of the most insidious forms of cybercrime. There is a necessity for a multifaceted approach, legislation, public awareness, campaigns, technological innovations, and collaborative initiatives. Though steps have been taken by the government, more serious measures are required. It is right and high time to launch a public campaign through print, electronic, and social media, television, and FM radio, ensuring that awareness is spread every hour, every day. These judicial trends reflect a clear trajectory. Our courts are not merely adjudicating individual disputes, they are pushing the state to rethink its entire apparatus of law enforcement and to change its strategy. The consistent refrain is that new age crimes require new age investigations, new institutions, and above all, a new seriousness of purpose. As we reflect on these judicial responses, we must also recognize the deeper constitutional questions raised by this new landscape. Cybercrime, in its new many avatars, whether digital arrest, sextortion, crypto scams, or deepfake impersonation, has forced us to revisit the fundamental balance between the law enforcement and the privacy rights. Friends, our Constitution guarantees the right to life and personal liberty under Article 21. In the case of Justice K.S. Puttaswamy, the court unequivocally declared that the right to privacy is intrinsic to human dignity and liberty. Yet, in that landmark ruling, the court recognized that privacy is not absolute. It may be curtailed by a procedure established by law, provided such curtailment is proportionate, necessary, and in pursuit of a legitimate aim. In this digital age, this proportionality test acquires a renewed urgency. Every investigative tool, whether it be interception of calls, tracing of IP addresses, decryption of devices, or compelled data disclosure from intermediaries, touches upon sphere of privacy. The line between surveillance for public safety and intrusion into private life is often blurred. The challenge is acute because the cybercrime does not respect borders. A fraudulent call may originate in one country, be routed through servers in another, and victimize an individual in the third. Investigators, therefore, demand speed, access, and expanded authority. But we must ask, how do we grant such powers while ensuring that they are not misused? Recent judicial pronouncements, which I just referred to, have sounded a note of caution. Courts have warned that weak investigative capacity must not become an excuse for indiscriminate surveillance. The call for cyber command centers and specialized cybercrime bureaus is precisely to ensure that technological competence replaces blunt overreach. It is not enough to empower ordinary investigators with extraordinary powers. Rather, we must train a new cadre of officers capable of piercing encryption and unearthing data theft without compromising the constitutional guarantees. I shall quote Timsux Wales, the author of the book Privacy Not Found, where he says, every piece of data shared is a footprint in the sand of our future, and some of those footprints are never erased. Unquote. The government, my friends, has taken some steps in this regard. The Information Technology Act 2000, with its amendments, the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, and the most recent Digital Personal Data Protection Act 2023 attempt to create a statutory framework balancing innovation with accountability. These laws impose obligations on intermediaries, mandate data safeguards, and provide for penalties in cases of misuse. As per the Digital Arrest Scam report by the Minister of State for Home Affairs, more than 1,700 Skype IDs and 60,000 WhatsApp accounts which were used for such scams have been blocked. Over 6.6 lakhs fraudulent SIM cards have been deactivated. Telecom companies have been directed to filter spoofed international calls that appear to be from Indian numbers. And the Citizen Financial Cyber Fraud Reporting and Management System has saved more than 3,400 crores by enabling instant reporting and blocking of fraudulent transfers. And yet, friends, the gaps remain. There is still no provision in our laws that specifically recognizes a digital arrest. Victims remain vulnerable because the scam itself is new, hybrid, and psychological in nature. Criminals sit across borders, shielded by weak jurisdictions, and exploit the delay in international cooperation. Therefore, the way forward must be twofold. Domestically, we must legislate clearly, recognizing digital arrests as a distinct offense with appropriate penalties and ensuring that our police are trained to investigate them. Internationally, we must forge alliances because cyber criminals know no borders and neither should justice. I must state honestly that legislation alone cannot suffice. Public awareness and empowerment are equally essential. A vigilant citizenry, informed of its rights and risks, is the strongest defense against cyber predators. The university can take up a project with the collaboration of the State Legal Service Authority, whereby it sends out its students amongst the vulnerable citizens by way of public outreach, training them about the risks of these digital arrests and how to avoid them. To borrow the words of Justice Subbarao in Kharak Singh versus State of UP, the right to personal liberty takes in not only a right to be free from restrictions placed on one's movements, but also from encroachments into one's private life. That wisdom resonates even more today. For if digital arrest is a new form of captivity, then unregulated surveillance can be a new form of state overreach. Our task, therefore, is to navigate this fine balance, empowering the state to protect citizens from faceless criminals while also protecting citizens from the facelessness of unchecked surveillance. It is here that law, privacy, and technology must converge in the service of justice. While the problem may manifest with unique intensity in India, the struggle is truly global. Every nation is grappling with the twin imperatives of empowering law enforcement and safeguarding civil liberties in the digital age. In the United States, agencies such as Federal Bureau of Investigation have long established special cybercrime units. The success of the joint CBI FBI operation that dismantled a 400 million USD fraud ring is a striking reminder that transnational cooperation is not a luxury but a necessity. The United States has also adopted frameworks like the Cloud Act, that is, clarifying lawful overseas use of data act, enabling cross border access to data with safeguards for privacy. The lesson here is clear. In a world where crimes are committed across jurisdiction with a click, mutual legal assistance treaties must be strengthened and the cross border intelligence sharing institutionalized. Turning to the European Union, we see the pioneering role of the General Data Protection Regulation. It emphasizes on data minimization, consent, and accountability and has influenced global privacy standards. More importantly, the European Union has established the Europol European Cybercrime Center EC3, a central hub where the member states pool expertise, intelligence, and technological resources. For our country, where cybercrime often transcends state boundaries, the model of a federal cyber command center inspired by EC3 could serve as a blueprint. The United Kingdom has adopted a strong legislative framework through the Data Protection Act 2018 and has constantly updated its approach through the National Cyber Security Center. The UK experience teaches us the importance of the public-private partnerships. Many cyber frauds exploit the platforms of social media companies, payment gateways, and telecom networks. Unless these intermediaries are made responsible stakeholders, the state machinery alone will not suffice. Each of these jurisdictions offers us a valuable insight. From the US, where we learn the importance of cross-border cooperation. From the EU, the lesson of strong data protection and centralized expertise. From the UK, the necessity of partnership with the private sector. And I will share a very surprising information with you. Recently, we had visited Japan, and I was told that because of this threat of cybercrime and encroachment into data privacy, the big companies, the corporates, have shifted back to meetings with no digital presence. The board meetings are all carried out on paper. Not a single digital device is allowed inside the meeting spaces. So that is going backwards, a retrograde step, but yes, it has become essential because of the threat of the cybercrime. For India, a nation of 1.4 billion people with one of the world's fastest growing digital economies, these lessons are not optional, they are essential. We must build a system that combines robust institutional architecture, stringent data protection laws, constant public awareness campaigns, and international collaboration. Only then can we ensure that technology remains a tool of empowerment and not of exploitation. Where do we go from here? What is the way forward? We must strengthen our institutions. We cannot fight tomorrow's battles with yesterday's tools. We need investigators who are just not police officers, but forensic experts, code breakers, and data analysts. The field is wide open for the bright young students of today to fill these spaces. We must clarify our laws. The IT Act gave us a beginning. The Data Protection Act added a layer, but the threats have outpaced the statutes. We need a comprehensive cybercrime law, one that names and punishes the new age frauds, digital arrest, sextortion, deepfake blackmail, and does so firmly while respecting the privacy of the citizens. Thirdly, we must look outward. Cybercrime does not stop at Vaga or at the Himalayas. It does not recognize borders. That means India must engage with the world, whether through the Budapest Convention or the United Nations process. It must be ensured that our investigators are not left waiting for a month when every hour of delay strengthens the criminal. Fourthly, we must bring the private sector into the fold. Telecom companies, payment gateways, and social media platforms are the very highways on which the cybercrime travels. They cannot remain passive spectators. They must be made partners in this fight. Fifth, and most importantly, we must awaken the society itself. No law, no police, no court can succeed if the citizens remain unaware and uninformed. As one of our high courts reminded recently, awareness must be spread every hour, every day, from classrooms to boardrooms, from television screens to mobile alerts. We must educate our people that vigilance is the first shield. And let me add this word of caution. While we empower the state to protect us, we must also restrain the state from overreaching. In this zeal to fight crime, we must not trample upon liberty. Surveillance must always be lawful, proportionate, and accountable. Otherwise, we risk defeating the very constitutional values which we seek to defend. And here, my young friends, dear students, you are central. You will write the codes that secure our networks. You will draft the laws that protect our data. You will argue the cases that define the balance between freedom and security. The future of India's digital justice system will rest as much as on your shoulders as on ours. Before I conclude, I must express my deep gratitude to the respected Chancellor, Dr. Pansare, the respected Vice Chancellor of the Royal Global University, Dr. Alak Kumar Buragoin, my esteemed brother, Justice Kaushik Goswami, Sri Devajit Saikia, Sri Boda, and the Royal Global University for having given me this opportunity to be amongst the bright young students and to inaugurate the largest gavel, which is the epitome of justice. Dear students, may you carry forward the spirit of inquiry, the courage to innovate, and the commitment to justice. Work together to build a future where technology is a force for empowerment, not exploitation, where rights are not eroded but enriched, and where India stands as a beacon of both digital security and constitutional liberty. Thank you. Jai Hind.